Hello, everyone, and thank you for joining us tonight. My name is Jeremy McLaughlin. I am the chair of the San Jose State University ASIS student chapter. Apologize again for any of the background noise during this introduction, but I am extremely happy to be introducing Kevin Smith, the director of the Office of Copyright and Scholarly Communications from Duke University. Kevin is a dangerous mix of both librarian and attorney who's experienced in copyright and technology law. There on the Duke campus, he helps to support scholarly communications, but also serves as a resource locally for the campus as well as nationally in regards to involvement with the changing landscape around scholarly publications, scholarly communications, digital copyright, etc. So we're very excited to have Kevin joining us tonight. And with that, I'll turn it over to Kevin and say thank you one more time.
Great. Thank you very much. And thank you, Jeremy, for the introduction and for organizing this. I'm delighted to be joining you all virtually this afternoon. I guess it's afternoon for most of you. So I have been asked to talk about digital copyright and technology. I plan to do a short presentation and then, well, a moderate-length presentation, and then have time, I hope, for questions and maybe answers. I would encourage you as I talk, if you have questions, to type them into the chat. Sometimes I'll see those questions and try and answer them as part of my, my regular talk. And if I don't, one of the moderators will capture them and feed them back to me at the question and answer session. So please do that if you think of something that you just have to get off your chest and know you won't remember for the next 10, 15, 20 minutes. I should say that I am both a librarian and an attorney. I don't know that it's a dangerous mix, but it is certainly a mix that makes my life very interesting. So with that, let me get started talking about digital copyright and technology, and that's as soon as I remind myself how to advance the slides. So the first thing I want to do is question the title that I was given. Question especially the part of it that says digital copyright. There really is no such thing as digital copyright or electronic rights or some kind of intellectual property right in things that are digital that is different than the intellectual property rights that exist in the analog world. Copyright law is at least supposed to be technologically neutral. Now, it's not always technologically neutral. In fact, there are a lot of instances, one that I'll get to before we even leave this slide, where copyright law is not technology neutral, where specific attempts have been made to address particular technologies, and especially digital technology. Most of those efforts are not very successful. It's very hard for Congress to keep up with the change, the pace of change in technology. And when they try to do so, they tend to do things that are often out of date before they're even adopted. So one of the early attempts to keep up with digital technology was when the record industry, this dates it a little bit, or the CD industry, no, it was the record industry really, was terribly concerned about digital audio tape. And they wanted Congress to do something about that tape that was threatening their survival. People would be able to record things off of live broadcasts like radio and not have to go out and buy records because that tape was such a perfect reproduction. Well, of course, that tape lasted about 10 minutes and was replaced by the CD. The provision, which is still in the law, is pretty much unused and unusable. So that's an example of why copyright tries to be technology neutral, because it's not good at being technology, well, I don't know what the alternative is, preferential. But the fact is that technological changes challenge the law, and they do change its contours. But when I say there's no such thing as digital copyright or electronic rights, I mean it. What we have is a bundle of rights that are given by copyright law. They are given to anybody who creates original expression that is fixed in a tangible form. It doesn't matter whether that tangible form is writing on a piece of paper or digital or a photograph or something made in a CAD program. All of those things are protected by copyrights, and they get the same bundle of rights. That bundle of rights doesn't include something that says electronic rights. That's a mistake that we make sometimes because we misunderstand the holding of a Supreme Court case called Tasani versus the New York Times. Sometimes people misstate the holding in Tasani by saying that the Supreme Court ruled that the New York Times didn't have electronic rights in works that had been written for the Times by freelance authors. That's not what the case held. It held that they didn't have sufficient rights under the contracts they had with their freelance authors to include certain works in certain types of digital products. But it was not a distinction between analog and digital rights. It was a distinction about the scope of the license that the New York Times had obtained from its authors. So the copyright bundle is the same, analog or digital. It includes the right to reproduce a work, to make copies, the right to distribute a work, that is, to distribute those copies, to hand them out or sell them or whatever you're going to do with them, or put them on the internet, to publicly perform a work, or publicly display a work. Some works lend themselves to performance and others to display. Public performance and display are within the control of the copyright holder, but private performances and private displays are not. And then there's the right to prepare derivative works, to make a translation, to adapt a novel to a movie script, that sort of thing. Those 5 rights are absolutely technologically neutral. However, and I told you I'd get to an example, the 6th right in the copyright bundle, which was added relatively recently, is the right to control the digital transmission of sound recordings. And so that's one, even in that bundle of rights, the most basic part of copyright law, that's one that's not technologically neutral. So it's an example, and I think a pernicious example, of Congress trying to meddle to control a technology that they're a little bit afraid of and that the people who lobby Congress are extremely afraid of. So what difference does digital make? Well, it's mostly pretty obvious. The speed of change, and that's something that frightens people. It's also a reason why the copyright exception called fair use is so very, very important in the digital environment, because it is the only exception to that bundle of 5 rights, the bundle of 5 things that the copyright owner has exclusive control over. It's the only exception to that exclusive control that is flexible enough to apply to different technologies. Most of the exceptions in copyright are very, very specific. They are things like you're allowed to take a picture of a building even though it's protected by copyright if you're standing in a place where you have the right to be, if you're not trespassing. Or you're allowed to sing a hymn in church even though that's a public performance of a copyrighted work. They're very, very specific like that, except for fair use. And so fair use is extraordinarily important as technology changes very, very quickly, because it's the only thing that can keep up with that change. And as we've seen, when Congress tries to do it by legislation, it's a slow process, and they almost always end up lagging behind. But fair use, which has been around for 160 years, is flexible enough, deliberately, intentionally, and from its very inception in 1841, fair use is designed to be agile, and the only real exception in copyright that we could honestly call agile. Obviously, the speed of distribution is another difference that digital makes. If you push that button, millions, perhaps billions of people can see what you just distributed, and maybe you didn't even mean to do it. Maybe it was just a, oh darn, I forgot. And we've seen lots of cases where people have been even prosecuted for file sharing, for sharing movies and music, because they download them to their computers and the programs they're using open a port where people can see and even copy those materials that the owner didn't intend to be there. So sometimes the software is doing something in the background, and that means that a mistake or an unintentional distribution can happen, and it can go to thousands and thousands and millions of people, and that creates a significant risk, and it's not very forgiving. There's not much way to take things back, to scrub things off the internet, in spite of what the courts in Germany have told us we need to do. And that's also the next point. The scale is really the same point, that so many people have access to things so quickly that does make an increase in the pressure that is on copyright law. And that scale is a reminder that when we think about copyright issues, we need to think in terms of risk analysis. A lot of things in copyright are not black and white. There are not yes and no answers. There is maybe you could make it safer if you did this. It's really risky because of that. There's an old joke that lawyers' answers to everything is it depends. And I like to say sort of, but the answer is really yes, but, or no, unless. There are always things we can do to make a particular project, a particular activity, more or less safe. So we should be thinking in terms of risk analysis. And then, of course, there is the fear factor. That really encompasses all of them. There are a lot of people and a lot of companies that are very, very frightened of the digital environment. They don't know how to control it. They don't know how they're going to make money out of it. You see this in the music industry, in the movie industry, and you also see it in the publishing industry. So there's a good deal of fear. And of course, what happens when people are afraid, I lost my drama by not being able to advance the slide quickly, is they sue folks. That's what happens when people are afraid. And remarkably, in the past few years, we have seen 4 major lawsuits against academic libraries or academics or universities for copyright infringement. That's unprecedented. That has not happened before, and it is because of these digital factors that I'm trying to tell you about. So on the one hand, I say there's no such thing as digital copyright, but on the other hand, it's certainly true that the digital environment has led to lawsuits that are all applying the old analog-based law, the law that was adopted in 1976, when the most threatening technology to be considered was the photocopier. They're trying to apply that law in the digital environment, and it's very, very difficult. I'm going to mute my microphone long enough to cough, so if you hear silence for a minute, be grateful. I'm sorry about that. I'm recovering from a sinus infection, and that may happen again. So let's think about these lawsuits, these 4 lawsuits, and they're listed there. Supak Kurtzong and the resale of textbooks, which is not a digital case, but which teaches us something interesting about digital. Georgia State University and the lawsuit over electronic reserves. UCLA and a lawsuit over digital streamed video. And the Hathi Trust and a lawsuit over mass digitization. So we're going to talk about all of those cases in the course of this discussion. We're going to look at what we can learn from the courts. I'm going to talk about 2 of them now, and I'm going to try to build a framework around these cases. And I'll talk about 2 of them now and 2 of them later on as I lead you through this framework. So the first of them is the case of Supak Kurtzong versus John Wiley. John Wiley is a textbook and scientific publisher. They sued Supak Kurtzong, who was a graduate student at Cornell University, because he got a very bright idea. He realized that in his home country, which was Thailand, textbooks were sold for a lot less than they're sold in the United States. And he figured out that he could get his family to buy textbooks for him in Thailand, send them to him in New York State, and he could resell them on eBay for a profit for him, but less than they sell for at retail in the United States. he made a lot of money. He made hundreds of thousands of dollars doing this. And John Wiley sued him. And the lower courts were undecided about whether or not this was copyright infringement or not. And the question was, does the doctrine of first sale, which is the doctrine that says that once you buy a particular copy of a work, you can do whatever you want with it. That is, you can resell it, you can loan it to a friend, you can put it in a library and loan it to hundreds of people. You can give it away, you can rent it, you can burn it. You can do anything you want with that particular legal copy. Any kind of further distribution. And first sale is also called the right of exhaustion in the distribution right. The exclusive right to distribute a work is exhausted after the first sale. That's the legal way we talk about it. The problem was the textbooks that Mr. Kurtzsang was buying were manufactured in other countries. And so the publisher said they weren't manufactured under U.S. law. U.S. law shouldn't apply to them. And so this doctrine of first sale should not have been used to allow Mr. Kurtzsang to resell the textbooks. The Court of Appeals, the Circuit Court of Appeals, agreed with the publishers and found Mr. Kurtzsang guilty of infringement. He appealed to the Supreme Court, and the Supreme Court reversed that opinion. They said that regardless of where a work was manufactured, as long as it was sold the first time by authority of the rights holder, in other words, it was a legal sale, whether it was in Thailand or the United States or Colombia, wherever, as long as it was sold under the authority of the rights holder that first time, the doctrine of first sale applied in the U.S. So once it came into the U.S., Supak Kurtzsang was entitled to resell it. This was extraordinarily important for libraries, but only because it preserved the status quo. It meant that we didn't have to distinguish between books in our collection or movies in our collection or DVDs that were manufactured in the United States versus those that were manufactured elsewhere. That would have been an impossible task. And actually, the Supreme Court took a lot of concern for libraries into account. In its decision, the court refers repeatedly to the chaos that would be created in libraries if we had to decide before we could loan a work whether or not it had been manufactured in the United States. So one of the reasons I like to bring up this case is because it's a reminder that the courts and Congress really like what we do in libraries. They like us a lot, just as Sally Field said at the Academy Award. You like us. You really like us. The court really does. So we usually get the benefit of the doubt from courts, even from the Supreme Court in this particular instance. But the other thing about Kurtzsang, and the reason it's important to think about it when talking about so-called digital copyright, is that it's a reminder that the doctrine of first sale only works in the analog environment. There is no such thing as a digital right of first sale. And the reason for that is that every time I distribute a work, a digital file, for example, there is a copy being made. It's not simply the case that I take the file and hand it to somebody else and no longer have it. A copy has been made. The other person has a different file than I had. So even if I remove my file, the courts have said that's a different copy. Copying is not included in the doctrine of first sale, not allowed by the doctrine of first sale. It's simply about the right of distribution. When a copy is being made, that's not first sale anymore. So the courts have told us, and there was a case that was decided about 2 weeks after the Supreme Court decided Kurtzsang, that said, yep, we know about Kurtzsang, but there is still no first sale in the digital environment. So one of the reforms we often talk about in our copyright law is some kind of digital first sale right, or what's sometimes called forward and delete. That is, you get the file, I no longer have it, first sale ought to apply. So far, there is no sign that Congress wants to do that. I'm just taking a minute to scan the chat because I know I'm going through a lot of material very quickly, but I don't see any questions, so I'll move on. The other case that actually didn't go very far was a lawsuit brought against UCLA for digitizing DVDs that they had purchased and streaming the digital files to students who were registered in particular classes so that they could watch the film on their own devices, on their own time, and not have to take classroom time to view the films. This was basically a kind of, we sometimes call it space shifting. Instead of having to watch the video here in the classroom with 30 other people, I can watch it on my own time with my little fuzzy socks on and my cat in my lap, as the picture illustrates. So this was a practice. I think most universities would like to do it. Quite a few are doing it to some degree or another. But this particular company, which was actually a video distribution company, brought a lawsuit claiming that it was copyright infringement. Now, the case was, I said it didn't go very far, and the reason for that is that it turns out that this distributor who brought the lawsuit didn't actually own copyright in any of the movies. So they didn't have standing. They didn't have the right to bring the case. And that was ultimately why the case was dismissed. It was dismissed twice. Dismissed the first time for lack of standing, and the distributing company, which was called AIME, A-I-M-E, tried to find copyright holders, legitimate copyright holders, that would join the lawsuit, and they couldn't. And ultimately the case was dismissed a second time. So there are two things I want to learn from that. The first is that the real rights holders in the movies that were being digitized and streamed didn't want to join the lawsuit. Now, I don't know for sure why they didn't want to join the lawsuit, but I can guess. I can guess that what they were afraid would happen was there would be a decision that went against them that said this was fair use. And they didn't want that established as a precedent in the Ninth Circuit Court of Appeals, which covers almost the entire western half of the United States. They just didn't want that kind of precedent. So they decided it was better to leave us in ignorance than to have a court decision that might go, might not, but it might go in a direction they didn't want to see. And in the decision, in the ruling that dismissed the case, the judge in this case acknowledged the fair use argument, and we'll be talking about fair use in detail in just a minute. She acknowledged the fair use argument and said that if she had to decide, she would find that argument plausible. But judges don't decide issues they don't have to decide, and she quite correctly said, that issue is not before me. This case is being dismissed on what we would consider a technicality, standing. So there was no decision about fair use. But still, it gives us a little bit of a hint about how fair use does and does not work in higher education. So before I talk about the specific cases involving fair use, I want to step back. Again, I'm going to take a look for questions. I want to step back and take a broader view of what we're talking about for a couple of minutes, and then I'll get back to fair use. When we're talking about new media, but really when we're talking about any kind of copyrightable content, there are always two questions. Who owns the new work, and how can I use existing content to create this new work, or how can other people use it to do other things? So there's the question of ownership and the question of use. I have been and will go back to focusing on use, but I do want to say a quick word about ownership. And I like this picture because some of you may know that the movie Hangover 2 involved a scene in which the person who has a hangover wakes up and discovers that he's gotten a facial tattoo, just like Mike Tyson's facial tattoo. Now, there's a sense in which this is a new media. It's certainly a media we hadn't considered before, a medium for creative expression that we haven't considered in the law very often. So I do
go get
have...
cough drop, bud.
I'm sorry? I don't know if we were supposed to hear that. Okay. Anyway, we have this issue of, and I'd like to ask all of you, tell me in the chat room if you're interested, who do you think owns the copyright in this tattoo? The answer here is that I'm starting to see questions now. Now at least somebody is telling me that tattoos aren't copyrightable, and other people are saying that the tattoo artist. I think they are protectable, at least potentially protectable, if the court finds that they are original expression. And the court has been very broad in terms of what is protectable expression. I think they probably are protectable, and I think you're right, that it is the tattoo artist who would own the copyright unless in some kind of strange agreement the person who was receiving the tattoo actually also obtained a transfer of copyright. In this case, actually, it was the artist who brought a lawsuit or threatened to bring a lawsuit to stop the distribution of the movie Hangover 2, which caused a lot of heartburn in the movie company, and ultimately, I think, led to a settlement so that they could distribute the movie on time. So I think it's correct that the artist owns the copyright. What I think is interesting is to think about what would be the remedy. Suppose this actually happened and this artist had a tattoo that infringed the copyright of the artist who made the tattoo, who designed the tattoo that's on Mike Tyson. What would be the remedy? I don't think a court could order somebody to go and get rid of the tattoo. That's just too intrusive of personal liberty. I think it's much more likely that a court would require a payment of money, but say, you know, you did it to yourself, you get to keep it, for better or for worse. Anyway, that's a digression. But as I say, it's kind of coming to terms with a new medium. I think the courts had not before had to deal with tattoos in such a, dare I say, in-your-face way. Anyway, going on about ownership, because I think, oh, at least somebody's laughing at my joke. Going on about ownership, copyright vests automatically as soon as original expression is fixed in tangible form. And the creator of that original expression is the owner of copyright. This means you don't have to do anything to get copyright. There is no need for the C in a circle, no need for registration, nothing. So potentially, if it's an original design, a tattoo is protected by copyright as soon as it is applied to the skin of another person. That means that most everything on the internet is protected by copyright, whether it says it is or not. With new media, there are basically two issues about ownership that I want to flag for you, and then I'll move on back to the question of use. The first is that more work in the digital environment is collaborative. So there is more need than there ever was before to be aware of joint authorship and the way that copyright can be exercised by joint owners of copyright. So many things are created by multiple people now, and multiple people may contribute protectable expression. If you think about a digital humanities project, for example, there is whatever the scholarly content is, there is also programming, and the programming is protectable by copyright. There may be graphic design done by another person. There are a lot of different kinds of protectable expression in many digital humanities projects, for just to take one example. The rule is that joint authors can each exercise copyright without the permission of the others. So the graphic designer can decide to distribute the project even without permission of, say, the literary scholar or the programmer. And that means it's really, really important in the digital environment to have clear agreements with the people with whom you are co-creating works. The other thing that new media brings up, in most institutions of higher education anyway, we have policies that say, regardless of what the law says about so-called work made for hire, in the university we don't consider scholarly works work made for hire. That is, when I publish an article or a book, Duke University doesn't claim it. I'm the copyright holder, and they have an explicit policy that says that their faculty and administration are the copyright holders in those kinds of traditional scholarly works. But those policies that renounce work made for hire don't necessarily apply to new kinds of creations, to online courses, to digital humanities projects, to elaborate data sets. All of those things may pose problems that are not addressed in university policies and may mean that we have to go back and look at the issue of work made for hire. And that's all I'm going to say about ownership, because I want to get back to the use question. And I'm looking at the time and realizing I sort of need to move along. Sorry about that. Whenever all of the litigation that I'm describing to you, the two cases we've already talked about and the two more that I'm going to tell you about in a minute, all of them are focused on somebody using content that was created by a different person. In other words, it's use that generates the litigation. And that's why I want to be real clear about how we need to think about using other people's content, especially in the digital environment. And basically, there are 5 questions that I encourage you to ask. You should ask them in this order, in the order I'm going to give them to you, because that helps clarify how to think about a copyright problem, about a copyright use problem. And the first question is pretty obvious. Each of these questions is easy and very hard to answer. They're simple questions with difficult answers. The first question is there a copyright? Is it potentially in the public domain? I could spend an hour and a half at least talking to you about the public domain, and I'm not going to do that here. But in any case, it's important to remember that many works, and even things you find on the internet, may be in the public domain. It's not difficult to find a scan of Darwin's Origin of the Species on the internet. That's in the public domain. The text is in the public domain because the copyright is expired, and the scan doesn't add anything original to the text, and therefore does not get a separate copyright. First question, is there a copyright? Second question, is there a license that addresses my proposed use? And I saw somebody ask the question some ways back, does that mean, when I was talking about the UCLA case, that there could still be a fair use of a movie even if that violated the terms of the license under which that movie was obtained? The answer is probably not. If the license in any way circumscribes the use, then it's the license terms that will control. However, if the license doesn't say anything about use or doesn't say anything that's exclusive, like you can only use this in this way, then you would still have a fair use right. So that's my lawyer's "it depends" answer. But it's important to ask about the license before we get to the copyright exceptions, because the license certainly can, and they often do, override the copyright exceptions. And then the next question is there a specific exception? One of those exceptions, like I can take a picture of a building from a public place, or I can sing a hymn during the course of a worship service, or I can show a movie to a face-to-face classroom. There are lots of specific exceptions, and if they apply, it's best to look at them. The next question is it fair use? And that's where I'm going to put the emphasis for the rest of this talk. And then the fifth question, assuming that there is a copyright, there is no license, a specific exception does not apply, fair use does not seem to apply. Remember, fair use is always a judgment call. But let's assume that fair use does not apply. Then the fifth question is, who can I ask for permission? And permission always solves this problem. You can always go back to the rights holder or to some intermediary group like ASCAP or the Copyright Clearance Center to ask for permission. Those 5 questions in that order will walk you through most copyright use problems. And they'll help keep you on the right track so that you're not jumping around and asking the wrong question for the circumstances. This is always about looking at the facts of my particular use and figuring out how they impact the legal analysis. So this is really a way to work through the facts in your head. So let's talk about a couple of those other 2 cases, those fair use cases. The first of them involved the Authors Guild versus the Hathi Trust. There seems to be a stray character there. Sorry about that. The Authors Guild sued the Hathi Trust. The Hathi Trust is a collaboration between a bunch of universities. It's a nonprofit corporation that has custody of the digital files that were given back to the universities after the books were scanned for the Google Books project. Google gave digital files back to all those libraries that allowed their books to be scanned. Many of those libraries put those files into this trust called the Hathi Trust. Hathi is the Hindi word for elephant. So it's about memory. It's about keeping our culture safe. So, well, at least preserved, if not safe. In the case, there were a couple of important decisions. The case is over now. The first was the Authors Guild had said to the court, libraries already have certain rights. They have them under Section 108 of the Copyright Act that allows them to make copies for preservation and for interlibrary loan. Since Congress gave libraries those particular rights, those should be the only rights that libraries have. Libraries should not be able to raise fair use as a defense. That really scared the library community. I've already talked to you about why fair use is so important. And fortunately, both the trial court and the Second Circuit Court of Appeals rejected that argument. They said libraries do have fair use rights, so they can do more than what Section 108 authorizes. And this is a nice example of the interplay between a specific exception and fair use. The specific exception gives us certain rights to do certain things, interlibrary loan, making copies for preservation, that sort of thing. But it's not all we can do. We can still use fair use. And in fact, Section 108 itself actually says in subsection F, nothing in this section shall be construed to impair the rights under fair use. So it was a hard argument for the Authors Guild to make, and they lost it. And then the courts, both the lower court and the Court of Appeals, affirmed that 3 things that the Hathi Trust was doing, 3 purposes for the copies they were making. And the copies they were making were the copies on all the backup and mirror servers and that sort of thing. And that's what the Authors Guild had challenged. There were 3 purposes that were held to be transformative. Indexing, that is making it possible to search across the entire corpus of works, search for individual words and see them in context. Preservation, protecting the cultural heritage by making lots and lots of copies of the digital files in order to make sure that they're safe. And access for the visually or print disabled, that is providing digital files for use with assistive software. The courts were very clear that those 3 purposes were transformative, and when a court says that a use is transformative, it's almost certainly going to find that that use is also fair use. Transformative is one part of the analysis. It's usually considered as part of the first factor in the fair use analysis. As you may recall that when we're talking about fair use, we're told to balance 4 factors: the purpose and character of the use, the nature of the original, the amount that is used, and the impact of the use on the market for the original. When a court says that that first factor, the purpose and character of the use, is transformative, usually all the other factors line up. Because the courts will say, because it's transformative, the amount doesn't matter all that much as long as it's appropriate to this new purpose. And because it's transformative, there's no legitimate market that's being harmed. For example, in the HathiTrust case, the court said, you know, the fact that you can search a whole body of 12 million files of digital books to find particular words and see them in little 2-line snippets to see what the context is, doesn't impair the sale of any book. In fact, it may encourage the sale of books. So because it was transformative, because something new was happening, something that was not part of the original market for the work when it was first released, the court found that this was a fair use because transformative. It's really important here that the court thought that access for the print or visually disabled was a legitimate fair use, a legitimate transformative use. I think that's extremely important in libraries because we're going to see more and more requests to make works accessible through assistive software. And I think this is a case we can rely on to say we should do that and not worry too much about the copyright implications, that meeting our obligations to disabled students and faculty is far more important. You may know that the appeals court remanded on the issue of standing. If you heard that, it's not something that needs to impact us in our analysis, and it was settled in any case, so it's not something that we need to worry about. The other case, the other fair use case, is one that we do need to worry about in academic libraries. It's a case that is still going on. It's called Cambridge University Press et al. Versus Becker. It's better known as the Georgia State University case. It's the copyright infringement case brought by 4 publishers, not just Cambridge, but also Oxford University Press and Sage Publishing, challenging the practice of making digital copies of small excerpts from published books and making them available through learning management systems or library electronic reserve systems. The trial court opinion was quite favorable to the libraries. It found that in 70 of 75 challenged cases, this was a fair use. So it was good for libraries for as long as it lasted. It was appealed, and the 11th Circuit Court of Appeals reversed and remanded the case, sent it back to the lower court. And some of us who had thought that the first decision was a pretty good one were distressed by this, but actually the appellate court's ruling rejected much of what the publishers wanted. So it turns out not to be make things as difficult for libraries as we feared. One thing that was rejected is the application of the so-called classroom copying guidelines, which were adopted in 1976 as part of the legislative history of the copyright law, but were not part of the law itself and don't have the force of law. And the court said these guidelines were always intended to be minimum standards, not maximum standards. The publishers in this case, according to the court, were trying to use them as maximum standards, and the court wasn't going to allow that. One reason this is important is because a rule, or a supposed rule, that many libraries apply comes from these classroom copying guidelines, and that's the rule that says we can use something once under fair use, but if somebody wants to use it a second time in a later semester, we have to pay permission for that second time. The courts have said that's just really not true and it's not relevant. So that's been an important change for libraries that have relied on that rule. In one way, it's good that they don't need to rely on that rule anymore because it was a limitation on fair use that turns out to be unnecessary. On the other hand, libraries like rules because it makes things easier for them, and having to give up one of their rules is sometimes difficult. Another thing, you may know that there were cases quite a few years ago around course packs that were made at commercial copy shops. The courts said, and those cases found that those course packs were not fair use. The publishers said, well, if they weren't fair use in print, they shouldn't be fair use digitally. The court said, no, that's not a good application of the copy shop cases. And it's not the move from print to digital that makes a difference. What makes a difference is that in the so-called course pack cases, there were these commercial copy shops making the copies and selling them to the students, whereas in learning management systems or e-reserves, there is no commercial motive, and the copy is being made by a nonprofit educational institution. The court affirmed that even when a use was not transformative, and both courts felt that e-reserves was not a transformative use. Even when a use is not transformative, if the purpose is nonprofit and educational, that still favors fair use. Another thing the court said was that when a use is not transformative, we need to give extra weight to the issue of market harm. Remember, I told you that when a use was transformative, the courts have said, you know, the market issue isn't really all that important because it's a different kind of market for a transformative use. So when a use is not transformative, the court said you need to look extra hard at what harm you may be doing to the market. But it's still appropriate to look and see if there's a license available for the digital use. And if there is not such a license available, that lessens the chance of harm. The publishers wanted the court to say it doesn't matter whether there's a license available or not because it should be the rights holder's decision whether or not to grant digital copying rights, for example. But the court said no, if you've decided not to offer a license, we're going to permit a little more room for fair use. Now, it's not a free-for-all by any means, but there will be a little more room. So it's an important question for libraries right now, where do e-reserves stand? The answer is that there's still a lot of uncertainty. We are told that there should not be a bright line rule about amount. There is no 5%, 500 words, 10 minutes of a video. All of those rules that you may have heard are guesses. They're rules of thumb, but they're not part of the law. In the Georgia State case, the trial court judge said that she thought 10% or one chapter was a good maximum amount for fair use. The appeals court said no, you can't have a firm bright line rule. We won't accept your bright line rule of 10%, Judge Evans, and we won't accept the publisher's bright line rule of only 1,000 words. The amount that is appropriate still has to be evaluated in relationship to the purpose, not in relationship to a bright line number. Now, in my opinion, 10% is probably still a good number. It's probably still a safe number. And I told you at the beginning, a lot of this is about risk analysis. But it is not a rule. And as I've already told you, since this use was non-transformative, we are told to give extra weight to the market harm factor. I'm going to finish up here so we can get to questions. When we're looking at a transformative use, when we're trying to decide if something is a transformative use, there are really three pretty simple questions that we can ask ourselves. Will incorporating this material into something new help me make my new argument or deliver my new message? And that's the point. There's got to be some new meaning, new message, new aesthetic, whatever it is. Will it help my readers get that point, or my viewers get that point if I use this material? And am I using just the right amount to make that point? Not too much, not too little. That's the Goldilocks rule. The thing I like about the transformative fair use analysis is that it has a really close relationship to sound pedagogical planning. I want to use this set of images in a PowerPoint presentation. Well, ask myself, why? What do they add? Do they really add stuff? Am I commenting about them? Is my argument stronger? Or are they just pretty pictures? If they're just pretty pictures, you could substitute for them. You could go and find licensed material and substitute for them. So maybe you should do that. If you can't substitute for them, that argues that they're probably fair use. The more central they are to the pedagogical point, to what you're trying to teach, or to the scholarly point, what you're trying to argue, the more indispensable they are to that, the more likely they are to be fair use. So fair use really works, especially this transformative fair use analysis, really works very well in education. I was going to tell you quickly, I'm concerned about time, but about some of the transformative fair use cases. Very quickly, the Supreme Court basically created this analysis for us in the 1990s when it decided the case about the song "Oh Pretty Woman," which is illustrated here with Richard Gere and Julia Roberts, where Two Live Crew made a parody version of the song, and the music company, Acuff Rose Music, sued for copyright infringement. The court said this was transformative. It was a parody. Two Live Crew was making fun of this naive view of romance and female beauty. Maybe that's what they were doing. It's what the court thought they were doing, or said they thought that Two Live Crew was doing. In any case, parody was a kind of transformation. In another case called the Bill Graham Archives versus Dorling Kindersley, this book in the center, The Illustrated Trip, A History of the Grateful Dead, used 9 concert posters that were held by the Bill Graham Archive. They used them without permission after negotiations over a license failed, as markers on a timeline. And the court said that was a transformative use, that these concert posters, which were originally intended to advertise performance of the Grateful Dead, had become historical markers. And because that was a transformative use, because they were reduced in size, that is, that no more of the image was used than necessary, even though the entire posters were reproduced, they were reproduced in a small size that would not substitute for the original posters. Because of that reduced size, that different purpose, the court said this was transformative and therefore fair use. And then just recently we had a case where photographs taken by a photographer during a 7-year stay in Jamaica, documenting the lives of Rastafarians, the book was called Yes Rasta, Book of Photographs, were used by an artist, an appropriation artist, and you can see in the illustration the kinds of things that he did. He put these lozenges on people's faces. He put an electric guitar in the hands of this particular gentleman. He inserted a lot of clip art of nude women. I don't know what that tells you, and made collages of these photographs. A court found that that was a transformative fair use because there was this new aesthetic. So I give you these examples to try and help you get your head around what it is we mean by transformative use and these new purposes. So I have, do I want to go into this? I kind of do. I already talked to you about whether you can substitute for something. In working on MOOCs that Duke have been teaching, the massively open online classes, we had a case where a professor had a picture It's about evolutionary genetics, and he had a picture of a table full of tomatoes from a farmer's market. Apparently, at some point, the tomato did something that was evolutionary remarkable. I don't quite know what. But I asked him exactly the question I was telling you. Do you need this picture? Do you comment on features of this particular picture? He said, no, I just want to have a picture of tomatoes. So that was a case where we said, well, that's not a transformative use because you don't need this particular work. So what we'll do is we'll go out and find you a Creative Commons licensed photograph of tomatoes, and that worked just fine. In another case, a professor who was teaching a class about reasoning and argumentation wanted to use the Monty Python clip, the famous skit called the Argument Clinic. It's 9 minutes long. He initially wanted to use all of it. We said, well, how much are you actually talking about? He said, well, 4 different spots I talk about what they actually say in the clip. And what we ultimately decided to do, and the digital environment facilitates this, we gave all the students in his MOOC a link, said follow this to the authorized Monty Python YouTube channel, of which there is one, watch the Argument Clinic, and then come back to the lecture. And then in the lecture, we took shorter excerpts, none of them are more than 20 seconds long, of the particular parts of the clinic skit that our professor wanted to talk about. So he had that material there. He could subject it to criticism and comment. It was clearly fair use for those small clips, but it might not have been fair use if we had taken the entire skit and copied it into his lecture. So that's the Goldilocks rule at work. We want to use just the right amount of material to make the new pedagogical or scholarly point. And that's the end of what I had to say. I'm sorry I went over a little bit, but I'll be happy to entertain your questions, and I think Marissa is going to help with that.
Hi, everyone. This is Marissa. Can you hear me? If you can you please give me a smiley face on the chat box, please? Thank you. Thank you. The first question comes from Sue. She's asked, notwithstanding a license to contrary, then could a university make the case that digitalizing its videos for streaming to students is a fair use?
I think I partly addressed that question, and the answer really is it depends. It depends on the terms of the license. If the license is very specific about what uses are permitted or what uses are forbidden, then that may well override fair use. But if the license doesn't mention fair use or doesn't say these are the only uses you can make, then you would still have fair use available. The terms of the question, Sue, you said, notwithstanding a license to the contrary, could you still make a fair use argument? The answer is probably no.
Next question comes from Sarah N. And she asks, how does the first sale doctrine relate to ebooks? If we pay the same for ebook and physical book, shouldn't we be allowed to lend or resell the ebook? Otherwise, we are paying for less valuable book if we buy an ebook.
A great question. And I think you're right. We are paying for a less valuable book. And it's very similar to the question that I just answered. If the contract, if the license under which we get the ebook restricts our ability to lend it, we have to follow those licensing terms. We agreed to them. If they are more restrictive than what we can do with a physical book, and of course they usually are, you're right, we're getting less value for our money, and we should negotiate on that basis. We should negotiate the price on the basis of this lesser value. But remember when I was talking about first sale, I said first sale doesn't apply in the digital realm because every transaction is a copy. When I buy a book, a physical book, I have the right to lend it, sell it, rent it, whatever I want to do, but I don't have the right to make more copies of it. I can't run them off on my home photocopier and sell 7 copies where I bought just 1. Copying is not included in first sale because the digital realm always involves copying. First sale really doesn't apply to digital files, including ebooks. So we are entirely at the mercy of the licenses we can negotiate. You're right, it may mean that we're getting less value, but that's the way it is, I'm afraid.
These are 3 questions from 3 different people, and they are very related to one another. Heather Zipperman, I was asking about Mike Tyson's tattoo artist, and Jeremy asked, what if I designed a tattoo and the artist draws it on me? And Sarah N. asked, is there any transfer of rights implied when a tattoo artist applies a tattoo?
Hey, Kevin, you may need to turn your microphone back on.
Thanks very much. You can hear me now, I trust. That's a great question. I want to deal first with the implied license question. By the way, I'm at home and I have a dog who has a tendency to bark, which is why I'm turning off my microphone when I'm not talking. So if I get a facial tattoo, there is a kind of implied license. Remember that one of the things that the copyright holder has exclusive control over is public display of a work. Well, if a tattoo is applied to my face, I can display that tattoo wherever I go, no matter how public it is. And if I'm on television, as Mike Tyson also often is, he obviously doesn't have to pay the tattoo artist a license for every public display of his face. Because his face is the medium which contains the original work, I think it's absolutely correct that there is an implied license, at least for public display of the work. Going back to the other question about if I design a tattoo and have a tattoo artist put that tattoo on me, well, that means that I am the copyright holder as well as it were, the medium for the work of art. And so, yeah, I don't have to ask anybody's permission for anything. But in most cases, the designer is not the person who's wearing the tattoo. And so we have this odd situation where a person is wearing a work of art in which they do not hold copyright. And that's what creates the odd situation. They certainly have an implied license to do with their own body what they wish. It would border on slavery for us to tell somebody that because they had a tattoo, there were restrictions on where their face could be seen or what they could do with their body. That would be a serious problem, and that's why I said the remedies are severely limited for somebody claiming copyright infringement. But remember the case, the Mike Tyson case. The issue was it wasn't Tyson who had allegedly infringed the rights of the tattoo artist, but somebody else who copied the tattoo that they had seen on Mike Tyson's face and used it in a movie. And that's probably a legitimate claim for copyright infringement. And they tried to stop the distribution of the movie. And of course they did that in order to get money out of the production company. I think they did it successfully. But that's an interesting situation where the original work of art has been copied by a third party, neither the artist nor the person wearing the tattoo. Tattoos are fascinating, but they're a very small section of copyright law. So we have other questions?
Yes. The next question is also from Sarah H. What happens if the work is no longer available for purchase or sale?
Great question. That doesn't have any effect on its copyright status. Many, many, many millions of works are no longer available on the market, but are still protected by copyright. Now, for many years in the United States, copyright had to be renewed, and it lasted for a set length of time, 28 years plus 28 more, if it was renewed. So lots of things went into the public domain because nobody bothered to renew the copyright. They weren't making any money anymore. It wasn't available on the commercial market, so the copyright was not renewed. Now that's not the case. Copyright is automatic, and it always lasts for either 95 years or the life of the creator plus 70 years. So copyrights almost always, I will dare say always, outlive the creators by design. That means there's a ton of stuff out there that is protected by copyright but is no longer being used to make money, and we may not even know who owns the copyright or how to get in touch with them. That's what we call orphan works, and it's a serious problem, and it's getting worse, largely because of this change that we made in our copyright law, where copyright became absolutely automatic and lasts for the life of the creator plus 70 years.
Next question comes from Julie Carmen. She asks, can this presentation be published? And the answer is yes. This presentation will be published on our YouTube site, and it will also be in the San Jose State Scholars Works. The next question.
And that, by the way, let me interrupt you just long enough. That's because the San Jose State ASIS chapter has my permission to do that. Of course, I'm the copyright holder in this, and I can license it for those kinds of uses.
Next question comes from Sarah N. Regarding digitalization of personal archives, I take a photograph or a series of photographs documenting an item that may or may not be covered under copyright. For example, a diary of my grandmother. You would own the copyright of your photos, correct? The copyright of the diary would have vested in my grandmother, and after her death would descend by laws of the inheritance, correct? Would this be considered transformative?
Okay. Yeah, I think I get the point here. And this is a great way, I think we're probably close to the end, and a great way to end because it deals with a lot of different issues. Unpublished works are just as protected by copyright as published works. So your grandmother's diary, my own diary, things that I write just casually at home are protected by copyright. The creator owns the copyright, and the copyright remains with them until they transfer the right, which has to be done in writing, or they die. Once they die, once your grandmother passes away, the rights descend. If she writes a will and says, I leave my copyrights to my granddaughter, then you become the holder of the copyright. Very few people do that. The only people who do that are famous authors. Most of the time, copyright will descend to whoever is the residual heir, the person who gets whatever's left. Sometimes that's even designated by law because the will doesn't mention it. Somebody inherits a copyright. Copyrights do not just go off into the ether. Somebody inherits them and owns them. But as I was saying, in a great majority of cases, no one knows that they own the copyright. No one cares because there isn't any money to be made from it. With photographs, it is the photographer who owns the copyright. The person whose picture is taken does not have a copyright interest. This is hard for some people to understand. But I do not have a copyright in my face, although a tattoo artist who tattooed on my face might. But I do not have a copyright interest in my undecorated face. I may have a privacy interest. those are much narrower. But the copyright, I don't have any copyright say in how a photograph of me is used. The photographer has the copyright and has the exclusive control over how the photograph is used. So put together the diary and the photographs, and maybe some historical material describing the time in which your grandmother lived, and you want to put that all up in a website. Yes, I think that's probably transformative. You're using all of those things for different purposes. The more you emphasize those different purposes, the stronger your case for transformative fair use is going to be. So for example, when we've had doubts about digitizing some of our special collections in the Duke libraries, one of the things we've done has been to introduce pedagogical materials. Talk to faculty about how do you use this material in teaching? What's its historical significance? Can you write something? Can you allow us to record a brief interview with you or videotape you giving a lecture about this material and put that up with it so that it really frames this new purpose? That helps to strengthen the fair use argument when we want to digitize these special collections. And a lot of times, because we are talking about orphan works, which we've been describing in answering the past few questions, we have to rely on fair use because there is nobody to ask. So it's very important, this transformative fair use analysis and the kinds of things that we can do to strengthen that fair use case. And I think I'll stop there, and I think we're out of time. Hello.
Yeah, thank you, Kevin. Sorry,